It's the first of a series of webinars by our Labor and Employment Group. Many of you have received an invitation for our 2017 webinars. We have webinars both by our OSHA group as well as our Labor and Employment Group. And these webinars are designed to provide information regarding new developments, practical advice for businesses in navigating these new laws. Now, to begin with, this webinar is the first of our series specifically involving California new developments. As you can imagine, California has been quite active on the employment front and is expected to veer substantially from the feds in the employment arena, particularly under the new administration in D.C. I'm joined today by Lindsay DeSalvo. My name is Andrew Summer. We are both attorneys with Conn Maciel Carey, a labor and employment boutique firm specializing in employment counseling and litigation, as well as OSHA workplace safety defense. Wanted to provide you just briefly some information about myself. I'm a partner with Conn Maciel Carey's Labor and Employment and Workplace Safety Groups based in California. I've been practicing for almost 20 years exclusively in the labor and employment arena, both counseling businesses on labor and employment issues, everything from handbooks and counseling, as well as litigating labor and employment cases at the trial court level all the way up to appeals in state and federal court. I also head up our Cal OSHA practice in California, and we will be having a Cal OSHA webinar on new developments as well later in the spring, and hopefully you've received an invite for that as well. I'll allow Lindsay to introduce herself.
All right. Hi, everyone. My name is Lindsay DeSalvo, and I'm an associate at Conn Maciel Carey in both the labor and employment practice as well as our safety and health practice. In that capacity, I support employers and represent them in such issues as wage and hour disputes and claims of employment discrimination. And on the safety and health side, I provide representation and counsel to employers through administrative enforcement actions, specifically those brought by both federal OSHA as well as Cal OSHA. I'll turn it back over to Andrew to start us off.
Okay, so I wanted to cover the agenda for today. There has been a flurry of new California employment laws taking effect in 2017. There are a number of laws both in the private and public sector, and the California legislature has been quite active, going to focus on the private sector employers and the impact on them, and then also address new developments by the municipalities, San Francisco, San Jose, Los Angeles, and others, and then some key case developments that have come out towards the end of the year. We in California have had both a Democratic governor and legislature since 2010. And I do recall a time when there really weren't that many new legislative developments. But ever since 2010, we've had a very constant flow of new cases year after year. Our governor, Jerry Brown, has vetoed some of the employment legislation, but tends to be very supportive of the legislative endeavors. And as a result, over the last 2-3 years that our firm, which is the Labor and Employment Boutique Firm, has been in existence, we've been conducting these annual reviews of the new employment laws since they've been so substantial. We've also seen in recent years the municipalities getting into the action and implementing their own laws, oftentimes in conflict with state laws. It has made it really tricky for employers to navigate this area. We or as I mentioned, there's been this constant stream of new California employment cases, and we've made an effort to focus on the ones that may be most significant to you. There's also been a pretty aggressive agenda in California by the state agencies, whether it be the Labor Commissioner on wage and hour claims, Cal OSHA on workplace safety issues, and we have seen rulemaking on the state level. We've had new regulations by the Department of Fair Employment and Housing. We've had new regulations by Cal OSHA. We've also seen an emphasis on enforcement, and Cal OSHA has been quite aggressive in this area. There has been a similar effort on the federal front, but we'll have to see what happens. It would be expected that there will be a tapering of the enforcement actions on that level, whereas on the California front, it will likely remain the same and perhaps become more enhanced over time. A recent development was the legislature's announcement in California that they have retained former U.S. Attorney General Eric Holder to represent the state in potential litigation against the Trump administration. So it's very likely that we will see issues concerning climate change, immigration, expansion of government-subsidized health care, legalized marijuana, all of those issues being litigated here in California to kind of maintain the state's independent interests. Now, first covering the major California employment laws. One of great significance is the SB 1241 that bars employers from adopting form selection clauses that require employees to litigate disputes outside of the state. So under existing law, there is the ability for employers to, in an employment agreement, select a location outside of California, potentially for litigating a dispute that arises under that agreement. That has typically been the case where there are corporate headquarters by the company that are in a different state. And the courts have often deferred to the form selection clause where there is some contact with that other state. As an example of the state taking an aggressive stance protecting what they perceive as the rights of employees, California has revamped this and has created this new law that essentially requires that any employment agreement involving an employee who primarily resides and works in California must provide for the litigation of any dispute arising under that agreement in the state of California. And specifically, that new law states that it concerns any claim arising in California, any employee who primarily resides and works in California. And so it will be important to revamp any employment agreements, offer letters, anything that might contain a form selection provision so it's consistent with the new law. This law also provides that an employer may not interfere with the substantive protections under California law concerning any agreement with an employee primarily residing and working in California. It's unclear what the force and effect will be of that requirement, since under existing law, employers are prohibited from imposing the laws under other states that are in conflict with the laws of California, for which there is an important public interest. So this often comes up in the context of where you have a non-compete agreement, and the employer, who may operate nationwide, imposes in an agreement a requirement from another state that is in conflict with an important protection that exists under California law. So what's important to note about about this new law, which is SB 1241, is that this requirement applies to any agreement with an employee who primarily works and resides in California. So it can apply to a confidentiality agreement, it can apply to an executive agreement or a severance agreement, it can apply to an offer letter, anything that can be construed as an agreement with the employee. The law takes effect January 1st, and it applies very significantly not just to the initial agreement, but also any modification or extension to an existing agreement. Meaning that if you have an existing agreement that you wish to extend, you'll need to modify that agreement in the extension to ensure that the form selection clause complies with this new law. There is one very notable exception to this law. If there is an employment agreement, a contract with an employee who is individually represented by counsel in the negotiation of that agreement, this form selection requirement does not apply, and the parties can agree to litigate any resulting dispute in essentially whatever form they decide is appropriate. Another really important consideration is that this new law gives teeth to potential litigation by employees seeking to enjoin any effort to enforce an unlawful employment agreement because of the foreign selection clause or the substantive law that is selected. This action could take the form of an employee filing suit requesting injunctive relief, essentially an order preventing the employer from enforcing the agreement, and can pursue other remedies available is what's stated in the new law. So conceivably that could be damages, an order barring the employer from seeking enforcement, and also attorney's fees. So it's very important in this context, as well as really anywhere there is an employment agreement that an employer is seeking to enforce that could be unlawful, that to be careful in how you go about seeking any sort of enforcement, that you review the agreement, that you ensure that you're not seeking to enforce an invalid agreement to the extent that that could result in very costly litigation down the line. Now, action items for what employers should do in light of this new law. We recommend updating your template employment agreements, whatever they may be, in a variety of forms, to ensure that the form selection and choice of law provisions are compliant, and that you're not relying on forms outside of California or laws outside of the state generally. And that also, when you go to modify or extend any agreements, that you ensure that the underlying agreements are compliant with the new law. And we also recommend that for any severance agreements with employees where they're represented by counsel in the negotiations, that you very clearly reflect in those agreements that the employees have legal representation, so that you're not encountering the situation where there is a form selection clause, if you should have one, that relies on litigation of that dispute outside of California, that not be found invalid. It's also good practice to reflect, for a variety of reasons, that there's representation by counsel when you're negotiating that agreement anyway, so that you can show that the employee clearly understood what was being agreed to, and was entering into the agreement voluntarily through the advice of counsel. The next law that we wanted to cover was an amendment to existing law concerning criminal background inquiries. As many of you may know, in California we have two separate statutes that prohibit employers from asking applicants for employment to disclose an arrest or detention that did not result in conviction. And this extends to a variety of situations involving diversion programs and convictions that have been expunged, that those are areas that cannot be inquired into in California. There's also a separate statute that prevents employers from inquiring into any misdemeanor marijuana conviction that is more than 2 years old. And an employer is not just barred from inquiring into these areas, but the employer may not rely on any resulting information it obtained in employment decisions. So this law, AB 1843, goes one step further and prohibits any inquiry in any aspect of a juvenile court proceeding. And that includes any arrest or detention, the court disposition such as the conviction, or any diversion program. And so it's important that in light of this new law that employers in California or doing business in California update their job descriptions to include a carve-out for juvenile court proceedings. I recommend having a caveat in the employment agreement for California employees or applicants, making it clear the areas in which they should not disclose criminal background information to ensure that you're not violating California law. Now there is one exception. Under this new law, a hospital or other healthcare facility may inquire into juvenile misdemeanor or felony convictions occurring within the past 5 years involving any sex crime as enumerated under the statute. And this applies to a hospital or health facility. A health facility is defined as a facility that, that maintains patients for a 24-hour stay or longer, among other requirements. And so unless you fall under those exceptions, under this new law, employers may not inquire at all into juvenile criminal history in the application process. So as I mentioned, what we recommend is revising job applications to exclude any inquiry in juvenile court proceedings for your California applicants. You may have a California-specific application if you do business nationwide, or you may have a carve-out exception listed in your application if you have one application you use nationwide. It is also helpful to ensure that the application makes clear that no other prohibited information should be disclosed, to list out the areas that they should not be providing information if you have a general request for information about criminal history. You'll also want to train your managers, particularly in the hiring process, to not inquire into these areas. This prohibition under California law concerning the inquiry into criminal history applies not just to the job application, but to any informal inquiry. And you can imagine the scenarios where hiring managers might overstep. The next area I wanted to cover was one that has developed recently under California law, and it's the equal pay law. And there's been a big political movement federally and on the state level. And California developed an equal pay law that applies to gender. And essentially, existing law has prohibited an employer from paying an employee at a lower wage rate than the opposite sex for substantially similar work. And substantially similar work has been defined to mean skill efforts, responsibilities, and working conditions that are similar. And that has been a new development under California law. And then just this last year, the California legislature expanded that equal pay law to include both race and ethnicity in addition to sex. And the California legislature has also clarified that an employee's prior salary cannot by itself justify a disparity in compensation. And so an employer cannot inquire into the salary that an employee earned prior to beginning the job and use that as the sole basis in setting compensation. And it appears that the motivation there was to prevent endemic discrimination where one might be overpaid and there's structural issues where they're basing it on the pay system that's already in effect in different workplaces. It's an area where employers will need to be more careful and in documenting the compensation decisions to avoid any equal pay claim. It's you want to what we would recommend is that HR or someone in a similar capacity within every company review compensation decisions and document them to ensure that there is some justification for a disparity in income between similar classifications under similar working situations. So it's important to note that under this law, although it's very broadly worded, there are certain exceptions, and the law does recognize that there can be a merit system that justifies a difference in compensation. So you may have a situation where you base compensation, at least in part, on performance reviews, and you can have some sort of formula or other practice that recognizes a change in compensation based on that performance review. You can also have a seniority system, which is typical in the union, public sector context, where the compensation may be based on your years of employment with the employer. There's also a recognized exception for compensation that's measured by the quantity or quality of production. So you can have a sales position, for example, where you are being evaluated based on your productivity, the number of items you sell, the services you provide, where that's something that can be quantified and that could be the basis for an increase in compensation. There is a catch-all exception that recognizes that there can be a bona fide factor other than race or ethnicity or gender, and that is a consideration that's not based on race, ethnicity, or gender. It must be job-related and consistent with business necessity. So examples of a bona fide factor may be education, training, or experience. And I'm confident that with our clients that there are legitimate considerations in the compensation decisions. However, there may be circumstances where the documentation is not good and that it would be difficult to back up the decisions that are being made. And that's an area in light of this equal pay law that, at least for California compensation practices, that there be some form of documentation supporting the decisions should there be a lawsuit down the line. All right, so moving down to the next new law, we have heat illness prevention standards. This was a very succinct new requirement in California. Essentially, under Cal OSHA, we have heat illness prevention standards that require documentation or heat illness prevention written document regarding the standard. And it applies to outdoor work, and it requires training of employees and supervisors regarding heat illness prevention, requires that there be access to fresh water and access to shade under those circumstances, and then has certain enhanced requirements for workplaces where there is high heat, defined as temperatures 95 degrees or above, and that involves the agriculture, construction, landscaping, transportation industries. And these requirements have teeth both in the Cal OSHA realm as well as civilly, since the California legislature has approved penalties for failing to provide heat recovery breaks. Now, the issue here is that this standard has traditionally applied to outdoor workplaces. In a presidential decision, however, in I believe 2015, that was the tri-state staffing case, Cal OSHA ruled that the injury and illness prevention program standard in California applied to also applied to indoor heat illness. In that case, there was a employees working in a warehouse, and there were concerns about the training that was received to prevent heat illness. And in that case, the Cal OSHA Appeals Board ruled that this employer failed to adequately train and instruct supervisors on the hazard of indoor heat illness. So it appeared that the issue might be settled. There was some disagreement about the scope, and it was uncertainty about how this would move forward. And then the California legislature stepped in and essentially instructed the Division of Occupational Safety and Health that enforces workplace safety matters under the Cal OSHA statutory scheme, instructed them to develop indoor standards for heat illness and injury prevention. And so they have been tasked with developing proposed regulations for dealing with indoor workplaces and are required to submit the proposed regulation by January 1st of 2019. So we have 2 years for them to do so, and then the Standards Board under Cal OSHA will review and eventually adopt some form of that regulation. So on the horizon, not immediately, employers will be faced with heat illness prevention requirements in the indoor context. I assume this will apply to areas where, such as warehouses, where there are high heat situations despite being indoors, but it's really unclear at this point whether this would apply to offices and other workplaces where there traditionally aren't these heat illness concerns. Now I'm going to turn it over to Lindsay to discuss the all-gender restroom requirement.
All right. Well, good morning and good afternoon to everyone on the line. So I'm going to take some time now to go through some of the other recent legislation in California that could impact employers in both 2017 as well as actually over the next several years, many of which do begin in 2017. Some of them have a little bit later start dates. So the first one that we're just going to talk about pretty briefly is AB 1732, which is a law regulating single-user bathrooms. So this is a pretty straightforward law. The law requires that all single-user toilet facilities be identified as all gender by signage, and that they be designated for use by no more than one occupant at a time, or for family or for assisted use. The law actually defines single-user toilet facility as a toilet facility with no more than one water closet or one urinal with a locking mechanism that is controlled by the person using the facility. The law also authorizes inspectors as well as building and local officials to inspect these types of facilities for compliance. So they can come in to a business establishment or a place of public accommodation and go ahead and check and see if these single-user toilet facilities are being properly marked as all-gender facilities. This is significant to employers because they are now required to have all-gender facilities at their business establishments, if they own places of public accommodation, to the extent that they have single-user toilet facilities in those establishments. So the next law is, it's actually a series of laws that goes ahead and expands overtime eligibility in California. So in 2016, the California government also implemented a number of changes to its employee overtime eligibility for several different types of employees. One such change is incrementally increasing access to overtime for agricultural workers. So generally in California, employees cannot work more than 8 hours per day in any work day or 40 hours per week in any work week unless they receive overtime pay. However, agricultural workers have been historically exempt from this specific overtime requirement. Specifically, California's agricultural workers were entitled to overtime wages only when they worked more than 10 hours in a workday, more than 60 hours in a work week. So the new law signed by Governor Brown in September 2016 will incrementally lower the threshold hours for agricultural employees to qualify for overtime wages. And the way that this has been set up now, the wages that they will be entitled to, or I guess more the time frame for overtime wages, will become consistent with California's standard for most other employees by 2022. So as you can see on this slide, each year on January 1st, beginning in 2019, the threshold hours will drop by a half hour each year until it reaches 8 hours in any work day or 40 hours in any work week by 2022. So by 2022, if you have agricultural workers and they're working more than 8 hours a day, that's when overtime will start kicking in. The changes in the law actually also require agricultural employees to be paid double time for hours worked in excess of 12 hours in one work day, and that begins on January 1st, 2022. And it also subjects these workers to the requirement that they receive 1 day's rest in 7 days worked, or the equivalent of that many days off in a month. For small employers, and that would include all employers with 25 or fewer employees, this incremental phase-in does not actually begin until 2022. So for small employers, they will have to do this incremental change over the same period, but it will start January 1st, 2022, and it will end with that same 8 hours a day, 40 hours per week threshold before overtime kicks in by January 1st, 2025. And as you can see on this slide, the new law also vests the governor with the ability to temporarily suspend the current schedule. But if the governor exercises this authority, the implementation would be postponed for an additional year. However, it would still be expected that full implementation, so again, this requirement that they work 8 hours a day or 40 hours a week before overtime kicks in, would still be slated to be in full effect by January 1st, 2022. The changes to the state wage laws also include increased threshold wages for exempt private school teachers at elementary and secondary academic institutions in California. So in the past, private schools have been permitted to pay their teachers at a lower rate than public school teachers due to the applicable salary basis exemption, which was tied to the state minimum wage. However, Private schools will now, under this revision to the law, have to pay their teachers the greater of two options in order for those teachers to be able to maintain their exempt status. And those two options are either 100% of the lowest salary offered by any school district, or no less than 70% of the lowest scheduled salary offered by the school district or county in which the private school is located. And again, between those two options, the school would have to go with the greater of whatever that calculation is when they look at the available salary levels based on those two options. And this law applies to teachers with a teaching credential or a bachelor's degree, but would not apply to teachers who only have an emergency permit or an intern permit or an applicable waiver. It also doesn't apply to teaching assistants or instructional aides or daycare providers and student teachers. So there are some limitations, but it does include those private school teachers. And this requirement actually becomes effective in July 1st, 2017. So still a few months away, but something to be aware of if you are a private school and are employing private school teachers. And finally, California made access to overtime permanent for domestic workers by removing the sunset clause in the Domestic Workers Bill of Rights. And the sunset clause was put into the Domestic Workers Bill of Rights when it was put out, and it would have led to the expiration of the overtime protection provided in the Bill of Rights in January 2017. So this revision to the law effectively makes the current overtime scheme for different types of domestic workers permanent, as was established in the Domestic Workers Bill of Rights. So in addition to revising its wage laws, California also added a disclosure requirement to its law requiring protected leave for victims of domestic violence, sexual assault, or stalking. So under existing law, employees have certain rights to take unpaid leave without fear of retaliation or discharge or anything like that if the employee is a victim of domestic violence, sexual assault, or stalking. So this is a law that has already been established in California. And under this law, the rights that the employee has include taking time off to obtain services, to seek medical attention or psychological counseling, or to participate in safety planning or figuring out strategies for protection going forward, among other things. And again, they have the ability to take this unpaid leave without fear of being terminated or retaliated against or being discriminated for exercising these rights. So what AB 2337 does is it adds a requirement to disclose to employees their rights under this law through written notice. Specifically, the notice must be provided to employees upon hire and to all other employees upon their request. The notice and the law generally is applicable to employers with 25 or more employees, although under California law, no employer can discharge, discriminate, or retaliate against an employee needing time off to seek assistance because they are a victim of domestic violence, sexual assault, or stalking. And the change in the law requires the Labor Commissioner to develop a template notice for employers to use to distribute to their employees, and the Labor Commissioner has to do this by July 1st, 2017. And the law actually also specifically says that employers will not be required to comply with this specific notice requirement until that template is developed, and specifically until it's posted on the Commissioner's website. So that's actually available to employers. They can take it, they can use it, and employers will not be subject to enforcement of this provision of the law until the Labor Commissioner does make that posting and make that template available to employers. Employers can actually also elect to use their own disclosure notice. If they don't want to use the one that's provided by the Labor Commissioner, they can develop their own. However, if an employer does choose to develop their own notice to distribute to their employees, it has to be substantially similar in content and clarity to the template notice that is generated by the Labor Commissioner. So, to ensure compliance and make sure, that you don't have any issues under this particular provision of the law, we would probably recommend that you use the sample template that's provided by the Labor Commissioner once it's made available, but it is within the employer's discretion to generate their own if they choose. So employers can take proactive measures to ensure that their employees are aware of their rights to protected leave, and help potentially avoid any allegation that it failed to uphold the employee's rights under this law as well as other protected leave laws by updating employee handbooks to provide notice of protected leave for victims of domestic violence, sexual assault, or stalking, as well as any other protected leave that is required under state or local laws, leave entitlements. Additionally, once the notice has been posted by the Labor Commissioner, you should make sure you're using the notice provided or that your notice reflects the similar content to the template, as well as making sure that it's really clear in a similar manner that the information is set out in that template. Employers could even use the template to provide notice to employees upon hire and then maintain a similar policy in an employee handbook just to ensure that those notice obligations are definitely met and that information is readily available to your employees. And then finally, in 2016, we also saw the passage of a law establishing a state-run retirement plan for California employees. So on September 29, 2016, the governor signed into law the California Secure Choice Retirement Savings Program. And this program will be based around a board-run trust into which employees can voluntarily invest a portion of their salaries toward their retirement savings. And investments will actually be made and managed through this board. And this board will be known as the California Secure Choice Retirement Savings Board, which makes sense based on the law. And it will be made up of 9 members that are appointed by the governor. So the employer's responsibilities under this law will be limited. Likely, employers will have to disseminate information to employees about, their opportunities to invest money and, engage in this program. And then they will also specifically be required to develop a mechanism to deduct employee wages for this purpose and provide the payroll contributions through which a payroll deposit retirement savings arrangement can be put into place for employees. Employers under this law will actually also be permitted to make their own voluntary contributions to employees' IRA if this is a benefit that an employer wants to offer, as long as those contributions are permitted under the Internal Revenue Code and wouldn't change this into an employee benefit plan under ERISA, which is something that we'll probably get more guidance on as this law goes into effect. If an employer did decide to make voluntary contributions to an employee's IRA, these contributions would not create any additional liability or anything like that for the employer. So it's completely, an optional thing, but good to know that there would not be any sort of liability created by doing so. Eligible employers under the law are those with 5 or more employees satisfying the requirements that are briefly described on this slide. And eligible employees are basically just those who are working for eligible employers with some limited exceptions. And actually, this law has been estimated to impact approximately 7 million workers in the private sector who do not currently have employer-sponsored retirement benefits. So the law will be implemented as of January 1st, 2017, or was implemented as of January 1st, 2017. But the specific requirements that are described here will not be triggered until the board actually opens enrollment to employees. And this is going to be done over a phased-in period. Participation will be tiered based on the size of the employer, giving some employers, smaller employers, up to 3 years to establish the required payroll deposit retirement savings arrangement. So, there is some time built in there to make sure that the infrastructure is in place to allow employees to start making investments once enrollment is open for employees. And actually, the board has discretion to extend these specified time limits. So if it's looking like employers could need more time to make sure that everything's in place and be able to set this up for their employees, the board can go ahead and extend these time periods and give them that additional time. Notably, employers do not have to participate in this program if they already offer an employer-sponsored retirement plan. And the law describes a few different plans that would be considered to meet this qualification under the law. A benefit plan, a 401k plan, a simplified employee pension plan, or savings incentive match plan for employees. Or it also would be acceptable if an employer offers an automatic enrollment payroll deduction IRA, as long as the plan or the IRA qualifies for favorable federal income tax treatment under the Internal Revenue Code. So if an employer already has something like that in place, it does not have to participate in the program that will be set up by the state, and will not have to then arrange for this mechanism through which employees will be able to invest in the state-run plan. So some additional details on the law that are helpful to understand. Eligible employees will be automatically enrolled in the program when it opens, unless they opt out. Those that are automatically enrolled will be enrolled at a 3% contribution rate, but employees will have the ability to choose to change that rate, raise it or lower it to whatever rate they feel comfortable with, they want to go with. An employee can also opt out of the program simply by making a notation on the opt-out form. But once an employee does opt out of the program, he or she can only enroll during the board's designated enrollment period. Employees, again, may choose not to participate at all, and the bill makes clear that employers are not responsible for the plan or liable as a plan sponsor. So again, employers are not going to have liability under the current law, and they also would not get any sort of additional liability if they choose to make a voluntary contribution to the employee's IRA. And then similar to an employee, as we discussed on the previous slide, an employer can opt out of this program as well. Even if an employer does not currently have recognized retirement plan set up for its employees, it could choose to opt out of the program once it does set up its own qualifying retirement plan, even if it does so after these requirements go into effect, instead of setting up a payroll deposit retirement savings arrangement, which is what is specifically required of the employer under this law. So with that, I'll now turn it back over to Andrew to discuss some of the significant local employment laws.
All right. So we've had another active year on the local front regarding employment laws. Traditionally, there were not many cities in California with specific employment laws, so that was deferred to the state. San Francisco became very active in this area, primarily first with the paid sick leave law that was enacted before the state even had enacted a paid sick leave requirement. And we have a number of different ordinances here in San Francisco, and it's important for any business doing work in San Francisco, having employees in San Francisco, be aware of the different requirements here. And then, recently we've had other municipalities getting involved in enacting various different ordinances, many of them patterned after what was first enacted in San Francisco. So, it would be a whole different webinar to cover all of the different local requirements, but we're going to cover the ones that just went into effect this past year. Going back to San Francisco this year enacted a paid family leave law, and this law applies to paid family leave that's available under California law. Just to start out with, it applies to leave that is taken for bonding with a new child. So it does not concern leave taken to care for a family member other than a child. So it would involve a situation where you would have a time taken off for the birth of a new child, the adoption or foster care placement of a child, and there's a phased-in approach here, similar to the retirement plan that Lindsay was discussing. We have in January 1st, this law goes into effect for any employers with 50 or more employees anywhere. And then in July of 2017, the law will then further apply to employers with 35 or more employees, and then January 1st of next year it will apply to any employers with 20 or more employees. Now, what does this new law cover? So first of all, it applies to employees that have worked for the employer for at least 180 days prior to the start of the leave period. So if you have an employee that just starts out, is there for a day and wants to take paid family leave under San Francisco law, they just simply wouldn't be eligible. That employee must also work at least 8 hours per week in San Francisco for the San Francisco law to apply. And at least 40% of the employee's total weekly hours must be worked for the employer in San Francisco. And to be eligible for this leave, the employee must be eligible for leave under the California Paid Family Leave Act. So essentially, the employee would be receiving benefits under the California Paid Family Leave Act for baby bonding, and the employer in San Francisco would be required to supplement that paid leave benefit. Let's go back. All right, so what do employers need to know? There is a cap on this entitlement. So for employees that have an annual compensation of $106,000 roughly or more, there's just a maximum weekly benefit of $1,129 per week. Then it's the benefit is otherwise supplemented based on a formula. It's important to note that this leave benefit is only for new child bonding, which is defined as bonding with the employee's minor child during the first year after the birth of the child or after placement of the child with the employee through foster care or adoption. And this benefit is only for 6 weeks of partial wage replacement consistent with California law. So skipping to next to the San Francisco ordinance, San Jose just enacted a hours ordinance, and just simply stated this was enacted by initiative and takes effect on March 8th, and it requires businesses with at least 36 employees to offer more hours to their part-time employees before hiring additional workers, provided that the extra hours wouldn't trigger overtime pay. So this was primarily motivated by the fact that some retail establishments might have primarily part-time employees, and that the city is attempting to force employers to extend the hours of part-time employees before hiring new employees. This law also bans retaliation against workers who exercise their rights under the law, and allows for court action. This law is similar to a big box ordinance for retail establishments that has been enacted previously in San Francisco. Okay. Now, Los Angeles has enacted a ban the box ordinance. That, again, is largely based on a San Francisco ban the box ordinance with some significant differences. We can't cover all the specifics, but you just need to know that this takes effect January 22nd. It covers employers doing business in the city of Los Angeles, and it prohibits them from asking about the criminal history on job applications, similar to San Francisco. And it's after a conditional offer has been made that employers may make inquiries, but you have to follow very specific procedures that are laid out under the ordinance. Specifically, employers must perform written assessment illustrating how the applicant's criminal history poses a risk to the duties of the position sought before withdrawing the offer. And this law applies to employers doing business in the city and employing 10 or more employees. It is also important to note that there's been a number of minimum wage increases throughout the state. We don't expect there to be any federal minimum wage increases, but certainly in the state there'll be an expected continuous progression upwards in the minimum wage. We have the state minimum wage increasing to $10.50, or it already increased to $10.50 January 1st. And then we have different municipalities that have minimum wage rates higher than that, and we have San Francisco on the high end, and that will be $14 on July 1st. We have other municipalities with their own minimum wage requirements that are not listed here, and it will be important to keep track of all the minimum wage requirements for the cities where you have employees. So let's discuss some key case developments. There's been a number of new cases that have come down. We have or we will cover here a couple of the significant ones that may be of greatest interest to you. Just recently, in December, the California Supreme Court issued a ruling on a significant rest period case. This involved ABM, which provides a variety of services, including security. And the context for this case is that in the trial court, there was I believe a $90 million verdict in a class action lawsuit against ABM for the alleged failure to provide rest breaks. And it involved a situation where security guards were allowed to take their rest breaks, encouraged to take them, but were on call during that break if there were any emergency, which would be understandable given the nature of their job. So there was this very significant verdict against the company. They then appealed to the California Appellate Court. They prevailed, and the verdict was vacated. And then the case was appealed one step further to the California Supreme Court. The California Supreme Court reviewed two issues: whether employers are required to permit their employees to take off-duty rest breaks, and whether employers may require their employees to remain on call during rest periods. Now, the Supreme Court issued a decision that was fairly employee-friendly and problematic, and something that you all need to be aware of. The Supreme Court, as expected, reaffirmed that there is a requirement to relieve employees of duties when the employees take their rest breaks. However, in this specific factual situation, they found that an employee cannot be expected to remain on call and to have a satisfactory rest break. And this case will likely go back down to the trial court. So the takeaway from this is that these rest breaks need to be time when the employee is not expected to perform any work on call or otherwise. And consistent with the Brinker case, which was another California Supreme Court decision decided some time ago, you're not required to police the breaks, but you need to make sure that employees are given every opportunity to take these breaks. And it's really important that you have very clear policies on providing employees meal and rest breaks, and that the supervisors are adequately trained on this requirement, and that there is no kind of operational situation that is effectively preventing employees from taking meal and rest breaks. And this, to note, this rest break requirement and meal period requirement applies in California only to non-exempt employees. Okay, the last case I wanted to address was Morris versus Ernst and Young. It was a arbitration case recently decided by the Ninth Circuit Court of Appeal, and that case decided the question about whether an arbitration agreement could preclude employees from bringing class actions or other collective actions in court concerning their wages, hours, or other terms or conditions of employment. In a very significant, far-reaching decision, the Ninth Circuit Court of Appeals that covers not just California, but the western region of the United States, found that that prohibition violated the National Labor Relations Act. And so in light of this decision, those of you that have arbitration agreements will need to consider revising them to ensure that these collective actions are not barred and having the appropriate carve out. That's something that you'll definitely want to consult with counsel about before enacting. Okay, so let's, with the remaining time, cover some of the questions that have been asked so far. There were a couple questions about the all-gender restroom requirement. It's not going to affect until March 1st, so you have some time. The requirement, to note, requires that they be identified, these restrooms, as all gender. And that signage must comply with Title 24 of the California Code of Regulations. I'm not aware of any specific all-gender signage being approved by the state yet, but it's something we'll need to keep an eye out on. But the first question was whether this rule applies to offices and other establishments not open to the public. So now this is the quandary we're encountering, and Lindsay, chime in if you have any other thoughts about this. But the law specifically states that it applies to places of public accommodation, which that would be, that could be a hotel that is a business open to the general public, but it also applies to business establishments. And so that could be construed as applying to an employer that's running a business. You could argue it could apply to a business at home if you are employing people. So I don't think we have any clear guidance right now. I would interpret this to mean that that all employers will need to have appropriate signage and designate single-user restroom as all gender.
I agree. It's the law that this particular new legislation would change requires that business establishments provide a sufficient amount of available restrooms for their employees. So when they say business establishment in this context as well, it does appear that it would apply to all businesses, including private business establishments that don't necessarily have the public regularly coming in. It would still be applicable there. But again, what it's really requiring is that signage, sufficient signage that complies, be posted outside of that restroom to indicate that it is all gender.
And another question that was posed was whether this would apply to a family bathroom. And the law does state that it's for use, let's see here, it does make clear that the requirement applies to a restroom that's used for a family or assisted use. So if you may have someone using the restroom, for example, someone that may be disabled and have an assistant going in with them, or for a family, you would need to, from the appearance of this statute, comply with the all-gender requirement. And there was another question about whether if an employee has a domestic violence policy in the handbook, they're required to give out notice to the employees. And this is specific to the requirement that you provide leave for employees due to domestic violence, sexual assault. And the requirement is that you provide notice. It doesn't have to be the form adopted by the state. I oftentimes will advise clients to develop their own form or their own language, because oftentimes the language that's developed by the state can have a slant to it that is information you potentially would not want to share with employees. So as long as you comply with the requirement and disclose the key requirements under the law, you can certainly have your own language. And what would be helpful is once the form is developed by the state, you would want to look at it and make sure that you cover the key elements in your employee handbook if you're not going to distribute the form. The same situation arises with notice regarding sexual harassment or harassment generally, that there is a form developed by the Department of Fair Employment and Housing, but most employers will, rather than distribute that form, have in their employee handbook the key requirements. Another question that we have here is regarding whether SB 1241, which is the law prohibiting foreign selection requirements, whether it applies to contracts with temporary agencies. No, that law only applies to contracts between the employer and the employee. So it does not apply to third-party contracts. Okay, and then we had another question regarding the San Francisco paid leave. It is effective January 1st, 2017 for employers with 55 or more employees. What if I have an employee had a baby in December and he took 1 week off in December? Are we required to provide him with the supplemental paid leave for the next 5 weeks? And I've had that situation arise with various clients. And so my read of the ordinance is that assuming that there's compliance with the other requirements to be a covered employee, meaning that the employee has worked for the company for a sufficient period of time, you may be required to provide that paid leave in January, even though the baby bonding started earlier in the past year. And there was another question that was raised regarding paid sick leave, that a number of municipalities have enacted paid sick leave. Can we disregard those paid sick leave ordinances in light of the California paid sick leave law? And the answer is that you must comply with whichever law is more protective of employees, which really places employees in quite a quandary. So if you, for example, are in San Francisco, or maybe I can give a better example of a city that deviates more from the state law, let's see, or Oakland or Berkeley. If you look, what needs to happen is that you need to look at the state law and the local paid sick leave law, and any way in which the paid sick leave law on the local level is more protective of employees, that's the provision you'll need to follow in your paid sick leave law. So, for me, from my vantage point, this is incredibly frustrating because it's another example of California making things difficult for employers, and that really there should just be one state law that's simple to follow, and that's the end of the story. But unfortunately, those of you that are in those cities where there are local ordinances will need to take those into account. All right. Well, thank you for joining us today, and we will be distributing the PowerPoint presentation to you all for reference. And if you have any further questions, you can certainly reach out to us. And any information about our webinars in both our OSHA employment groups is listed on our website, and we invite you to participate in the future. Thank you for attending.
Thanks, everyone.